Law on the Street with our good friend, attorney Brian Pritchett from the Pritchett firm. Got to talk about last week. We went out after the show, right? Had a couple drinks.
We did, yes.
That was fun.
I'm going to take the fifth on that. No, it was a lot of fun.
We had a lot of fun.
A lot of fun.
But so the heartbeat bill, Judge Robert McBurney rescinded this law. One, is he right? What's your attorney legal expertise on this whole story?
Well, the entire reason that he found it in violation, and I'm going to use Latin here, so forgive me, and I'll spell it, ab initio, A-B-I-N-I-T-I-O.
You're a show-off.
I had to learn Latin.
Okay.
It means the law from the beginning was unconstitutional because it was passed at a time that Roe versus Wade was the stated and understood law of the land and had been since it was passed. So almost 47 years before that, when Roe versus Wade happened, before the HB 481, the Life Act. This is actually not the Heartbeat Bill, it's the Life Act is what they would call it because they don't want to make it sound like the Heartbeat Bill is what the opponents would call it.
Gotcha.
Yeah, so it was kind of crazy to think about.
So the Heartbeat Bill is not the real name of the bill?
It's the Life Act.
Okay, yeah. That's good. That's interesting. I learned something new. Go ahead.
And what he says is that the law itself, when it was passed, it was in stark violation of the U.S. constitutional authority that Supreme Court has in saying that abortion is legally protected as a federal right. So Georgia cannot go in there and restrict it further. So the law itself was in violation. Now, Georgia has an old, and a lot of states have this, a common law argument that if a law is passed and later something changes, right, but then they go back to look at that law and it was in violation of the situation at the time, then that law is void from the day it was passed. So even if situation changes in the future, like it did here, with the new decision that basically overturned Roe versus Wade, the law now, if they pass that bill now, it would be able to be sustained, right? But when it was passed, it was in violation of the U.S. Constitution. So you cannot use that. It's a void law from the beginning.
Because the Roe v. Wade would have voided it out.
Right.
So here we go. The legislative, we have a new House. We have a Republican-controlled House, Georgia House, Georgia Senate. We have a Republican governor, lieutenant governor, all the way down the board, all Republicans, almost a supermajority, very couple votes away from a supermajority. Do they just go back into the legislative session and just put this exact same law on the books now that Roe v. Wade has been overturned?
Well, if you look at the 6 states that tried to enact abortion bans this past election, they all failed. You take a poll of the people in the streets now, they don't want abortion to be outlawed because that takes away from a woman's autonomy. Bodily autonomy is a pretty big issue now. And what Judge McBurney put in his decision, I kind of wrote down so I don't screw up his words here, but he said that if anyone tries, the Georgia legislature will have the sharp glare of the public attention to see that the legislature will give more power to an unborn child than over a woman's right to bodily autonomy and her own person. So he said, if you guys want to do it, you got to do it, but we're going to see it. It's not going to be passed in the middle of the night. It's going to be in front of everybody. So that's why Planned Parenthood is still pushing this forward. Now, of course, that decision by Judge McBurney has already been appealed by the Attorney General. So it's going to go up and it will be heard by the Georgia Supreme Court, which more than likely, even if they affirm it, that's not going to stop the legislature from going and doing the same thing again.
That comment that you wrote, that Judge McBurney wrote in his ruling, isn't that a political comment from a judge? Would you? Let me ask you a question. Rephrase it. Would you frame that as a political argument? Because he's telling the legislature that whatever your law you pass, we will see it. That's a political comment, not a legal comment, isn't it?
Well, I don't think by putting sharp glare of public attention, that's a little bit stronger than I would suggest that a judge puts in an order or an award like that. But it isn't really untrue. He's saying this is what's going to happen because look at the polls, take the temperature of the country. Roe versus Wade was decided by a majority, the overturning of the Dobbs case, which overturned Roe versus Wade, was decided by a majority conservative Supreme Court. And the polls are like 60 to 75% in favor of going back to Roe versus Wade. So the Supreme Court is not listening to polls. They're looking at
The law.
Well, they're looking. Well,
They're looking at the law, right?
But they are looking at their conservative spin on the law and trying to like read the minds of the framers of the Constitution, which I always find to be quite funny.
So let me ask you this. So let me play devil's advocate, no pun intended. Is McBurney reading the mind or doing his own liberal spin on the law in this case, or do you think he's got standing that the Georgia Supreme Court will uphold his ruling?
I think his ruling is pretty solid.
Okay.
Because he went back to the ab initio void of that law. He said that the law was false and unenforceable from the beginning, so it should not have ever been in place.
Gotcha.
That is, and like I said, that doesn't mean it can't be changed now or reinstituted as a new statute. That's probably what's going to happen.
There are some polls, particularly here in Georgia, state polls, that show people may not want 6 weeks, but they'll be comfortable with something in the middle, like 15 weeks, meaning that there's a pro-life feeling amongst people, but they still want the women's autonomy of her own body. So you have this, it's kind of middle ground of within 15 weeks, you know you're pregnant, you know what I mean, the fetus is developed, maybe you have a 15-week. Do you think the state legislature, if they move the time from 6 weeks to 15 weeks, that becomes palatable? Not polling-wise, but legally.
Well, legally, they could do whatever the heck they want now.
Because of Roe v. Wade.
Because of Dobbs. Yeah, the Dobbs decision gave them the right to do that now. But I think that you're going to see a lot of backlash if they try to put another 6-week ban, because the problem is it's basic physiology. A doctor cannot tell if there is a viable fetus at that point. There's no way to tell just from a heartbeat. It's not even a heart. It's a muscle that's inside the fetus that's formed. And I've got 4 children. I've gone to ultrasounds. I know. Yeah, exactly. But I'm just saying
I was going to say, I thought you were pregnant or something.
No.
Men can get pregnant now, so I thought maybe. I had to come back at you like that.
Goodness. Well, I'll take a pregnant pause there.
That's right.
So what I think the issue is going to be like they didn't talk to doctors here. They didn't talk to any of the groups that actually understand a woman's body, the physiology involved in that, because 6 weeks is way too early. A lot of women don't know they're pregnant until well past that point, and then it's illegal to take care of your own health. And that's, to me, that's a violation of constitutional right.
Of the woman.
Of the woman, yes.
And I guess pro-lifers would argue it's maybe the violation of the constitutional right of the baby. That's why I say a happy middle ground may be the 15-week. No, you don't think?
Well, 15 weeks is better than 6, but again, 15-week born child is not going to be a viable child. Gotcha. That's not going to happen. That's not going to work. That's not possible. So that's the problem here. I mean, if they're going to do that, then let's let pregnant women ride in the HOV lanes by themselves, because if we're going to give the rights to the fetus, let's let them, have a say in that.
I'm all for that too.
Argued she got a ticket, and she actually said, "Hey, I'm in the HOV lane. I'm pregnant. It should work."
Well, Texas, they would just shoot you.
You know what?
Now, why is my men can get pregnant joke frowned upon, but in Texas they can shoot you?
You ever been to Texas?
Yeah, no, not that part.
Yeah,
not that part. I've been to the urban part. Where it's safe.
It's law on the street. Attorney Brian Pritchard is here talking about that ruling. So as we look at the ruling, as we wrap that part of it up, you think what's the next step for this?
Well, I mean, the appeal is going to take place. It's going to go up to the Supreme Court of Georgia, and that will be the decision-making body will finally say yes or no to that, and that'll be over for that.
Look, I'm sorry to cut you off. That would be they'll make a decision on McBurney's ruling.
On McBurney's ruling,
gotcha.
Yes,
okay.
Yes, and then that will either say that the Life Act is good or bad law. At that point, the Supreme Court of Georgia can make that decision going back to the 2019 law, right? But the other issue is they're going to have a new law passed. I mean, that's what's going to happen. I believe Governor Kemp mentioned that in several of his campaign stops, that he was going to protect and further the heartbeat law, which is what he called it, because they want to make it sound like there is a viable heart at the time they can sense that, and that's why they call it the heartbeat law, even though it's the Life Act. So it's going to be redone. I don't see them going as early as 6 weeks. Maybe they will try 9, 12. I don't know. But again, until they get doctors involved and protect women, I don't see it being
popular.
Ethical.
Right. Ethical. Oh, I said popular. Ethical is a strong word.
It is.
Where do you think, if it goes to Georgia Supreme Court, the legislature hasn't come to anything, they can't vote on anything, there's a big back and forth, where do you think, just guessing legally, the Georgia Supreme Court falls on McBurney's ruling?
Well, if they just base it on the going back, hundreds of years, the ab initio factor that, the law itself was not viable at the time and I guess should have been aborted when it was passed, the Supreme Court might find
no pun intended.
That was intended.
Yeah.
The Supreme Court might find in favor and affirm his decision. But again, given that it's Georgia, you never know what's going to happen.
All right. Attorney Pritchett of the Pritchett firm. My man. Good stuff. Good
High
stuff.
fives in the
Good
studio.
stuff.
So a story we opened up the show talking about in the 7 o'clock hour has to do with a man who ended up getting arrested. Apparently he's a bounty hunter. He saw a car get hit. He saw the driver that hit the car run, chased him off of 400 Lenox Road. He's a bondsman, I guess. He pulls out his rifle. He takes his badge, puts his vest on, takes him out the car, marches him over to the police and say, hey, here's the guy. He gets arrested. The hit and run guy gets a citation.
Right.
And Shelley had said, isn't there a such thing as citizens arrest? This guy legally apparently went way too far.
Yes.
He said, yes.
Yes,
He went way too far.
He did.
But what about those of us that think, it's a good guy, you hit somebody, you ran, and then somebody called in and said that since Ahmaud Arbery, the laws have changed. Is it like a fine line doing that? And
it is taking the law into your own hands to the point where you are basically impersonating a police officer. You are doing the work of the police officer there when you step in and you try to physically take somebody under your control and custody. There's no right to that anymore. The citizen's arrest law was withdrawn. Governor Kemp signed that the repeal of that law with Ahmaud Arbery's mother in front of him. It was a law that went back to pre-Civil War times. It was for hunting down escaped slaves, for lynch mobs. That's what the citizen's arrest law was for. So it's a racist law to begin with. So it's no longer here in Georgia. Now, what the police will tell you and what anyone who understands the situation better will say, if you see something happen, you phone the police. You call them, 911, you tell them what's going on. You don't try to intercede and take over and grab that person. Now, also in this case, Milani Kai, the alleged bounty hunter fired his gun.
Oh, he did fire.
I didn't see that part.
So he discharged his gun.
I didn't see that
that's
part.
it for me. Yeah, he needs to
I
go
didn't
to
see
jail.
that part.
Milani Kai left that out.
I didn't see that part. I'm not going to say the
he needs
news
to go to
outlet.
jail.
They didn't put
he
that
needs
in
to go
there.
to jail.
Yeah, well, I'm just saying. I'm sorry. I just want to be,
Yeah, I didn't see that part in my story.
What did he fight? Like in the air to stop the guy?
more than likely to scare him from running.
Yeah.
But the thing is, bounty hunters in Georgia, they have specific rules they have to handle. They have to do certain training and all this other stuff. And we don't know if these guys really were legit bounty hunters.
And he I would hope he would have been one if he went up to the police. But before we go to the break, and maybe we can hold you over, Greg in Cleveland, Georgia has an honest question for you. Real quick, Greg, please get that question out because we got to run to the break.
So here's my question. When do states' rights overrule? For example, Colorado has legalized marijuana, although the federal government says it is illegal to have it. If the state of Georgia, if constituents vote to approve something like the heartbeat bill, does that overrule the federal statute?
Good question, Greg.
Thanks, Greg. Well, I'll answer that after the break, so hang tight.
Yeah, we're coming right back. It's Word
at
on the
you,
Street,
radio
Law on the
guy.
Street. Attorney Pritchett
Oh, man.
being all radio-ish and whatnot. We'll be back. He's going to answer that question.
It's not because we're funny.
No.
It's not because we know what we're talking